Thank you. I'll continue.
All right.
Judge, I have a scout here, this is number 7, number 15.
You know, from I added up the numbers in the back, and
Okay.
then on the third page, the number of hours, I put the same ones in the front, which was 15. Your Honor, order.
Gotcha. Yeah, no, just to make it even. Oh, I,
And I did the same one for the rest of the house.
I have to go after this.
okay.
Judge, you said hours 7 and 15.
Yes, sir.
Yes, Judge.
Laura?
Judge, number 7.
Thank you, Judge.
Yes, thank you.
Case for case management. I just wanted to make sure you pulled it from your calendar because.
Yeah, no, I had looked it up and I had seen it was a voluntary dismissal,
You
so,
said it before we dismissed.
yes,
So
yes,
that makes sense. So
Okay,
7 is off then for that
right,
purpose?
7's off the calendar, it's closed. The other one is 15.
Yes, that's correct, Judge. Plaintiff's motion to cancel sale.
All right, and,
We're set for sale on, it's like March 25th. And we're looking for cancellation based on continuing loss mitigation with the defendant. So we're asking you to cancel the sale and give me a reset tonight.
that there's continued loss mitigation on this 2010
Not
case.
that old, Judge, come on.
It's within the decade, I guess,
Is that old? It's okay.
barely.
Judge, in all seriousness, the defendant did enter into a consent judgment way back in the day
Right,
with an extended sale date in 2013, and thereafter he filed for bankruptcy. The bankruptcies were, the relief was granted, dismissed the case. Then there was 3 bankruptcies, as I understand it, filed on behalf of the defendant. The most recent evidence is that he's sent in some loan modification, and we have extended to him until March 31st to accept the offer that we put out there.
I know, which is a couple days after the sale. I mean,
Well, in order to be able to effectuate the offer, or to effect the offer, accept the offer, he's got to be able to have the full time frame given in that offer. That's paragraph 12 of our motion reads that.
all right, well, you gave it your best shot and
Understood.
it's too much.
Oh, okay. I'll prepare the order. Thank you.
All right,
Your Honor, number 4 on your calendar, Samir Mohammed on behalf of the plaintiff, Bank of America. Your Honor, this plaintiff's motion to appoint guardian ad litem.
yes, I'm granting it.
Do you have someone?
Well, that was what I was gonna ask you, because if not, I was gonna go back in and get
I
a,
do have David
the next-
Altschuler.
oh, okay, I know Mr. Alschuler, that's fine, yes.
Space.
May I approach, Your Honor?
Thank you.
Thank you, Your Honor.
Okay, thanks.
Is number 2 now, Judge? Judge, court order is
On, Citibank, Wilmington Trust versus, Lopez, 12-24863. Let me have appearances, please.
Greg Chief, on behalf of the plaintiff, Wilmington.
Okay.
Good morning, our chief on behalf of Mr. and Mrs. Lopez, who are present for court.
Okay, morning.
We're
All right.
here for a status conference. I'm
Right.
not exactly sure how to
I just figured I'd bring this all to the court and let the court decide what it thought was the best way to go. So procedurally, where we were was there was a trial. There was a motion for a hearing that was filed. Your Honor made very clear that you were holding the hearing in advance while they were going to consider my client for a loan modification. You had us go to mediation, and you came back after mediation saying, hey, they had always denied us and they never gave us the letter and we never got a chance to appeal. And we have a problem with all of this. Your Honor said to Mr. Wimbish, who was the counsel at the time, take this back, go talk to your people. You know, we know that. Your Honor heard from the testimony during the trial how hard my clients worked to try to save their home. They've never been offered any assistance to save their home in all the years they've been fighting this case. Your Honor made it very clear. I have this motion for rehearing that's pending. I'm not ruling on the motion for rehearing, despite Mr. Wimbich's request over and over to you just to end this. You said I want them reviewed. So
what happened?
So we did the appeal as was supposed to happen. And then they went forward with the sale while the appeal was pending. They sent us a letter just recently on March 7th, 2019, where they basically acknowledged there are errors on our part. We provided you with the incorrect denial, and normally we provide the proper denial letter, which included the appeal process for the customer. So they are acknowledging that they didn't complete the proper review. Meanwhile, not only did they sell the house, the date of the sale, they someone sent over to my client's house and popped all their locks open and left the door without locks on it, which caused my client severe distress. And just, it brought this whole thing back that no one understood why they were doing this. Under the regulations, they're not allowed to go forward with a sale while there's a review pending. So that's a federal lawsuit that is going to be coming down the pike now for what they did. They sent my client a letter that says on February 8th, 2019, that they referred this now for eviction proceedings, which again is completely improper and a violation of the Fair Debt Collection Practices Act. And ultimately, the response that they gave us, again, not only do they use a number that is higher than the judgment amount, a significantly higher number than the judgment amount, in denying our client. Someone at wellsfargo.com. This is a NationStar case. Why is Wells Fargo saying that they're denying this modification? And Mr. Wimbish said, that's just not true. I'm making this up. That's nothing to do with anything. Meanwhile, this same email is attached to the client. It is attached to their letter that's supposedly some kind of, actual denial of our appeal. But none of this is happening the way it's supposed to be happening, Your Honor. And it's causing my clients a lot of distress. And I just want to make sure the court's aware, since the court's entered the final judgment and while we are on rehearing, there have been multiple cases now that have come down from one from the second DCA, which expressly says, and I think Sorensen's the case Your Honor should look at, is the one that says you should grant rehearing, because it says that it is abuse of discretion on a case that I brought with the exact same fact pattern, the same endorsements and assignments. The second DCA has now ruled it is controlling law that you cannot, that is abuse of discretion not to allow me to plead that they added the endorsement after the fact, backdated by perjury, and submitted a false assignment of mortgage to back it all up. And that, Your Honor, was what I was trying to plead in this case. And I just think, Your Honor, it just seems so unfair that Your Honor gave them every opportunity to do the right thing. They could have fixed this problem and left my clients in a position where they could save their house. And these people have been scared and praying for years now that some miracle would happen. And today we're asking for the court to make that miracle happen and just grant the rehearing or do whatever Your Honor thinks is appropriate. But I think that it is highly improper for them to have pushed forward with the sale, popped my clients' locks, sent them a letter saying you're being evicted. All of that being done while Your Honor has said, I want to hear first what you did so I can make a decision as to what's next. And, all this is just in play. And I brought it to Your Honor as a status conference. I told all this to counsel who's new to the case. I don't know if he has any real knowledge of the history of fact patterns of this. But I think that ultimately, Your Honor, there couldn't be a more just resolution to the bank's position that they've taken throughout this entire case, which is we're not going to help you. We don't care if you're good people. We don't care if you tried. We're just not going to help you because we don't have to. And we have a judgment now, so for sure we're not going to help you. And we'll do whatever we got to do, including use mediation to block the court from finding out what we're doing. But again, this is what happens when you have this mindless, heartless entity that's just moving forward to take another home in a foreclosure, and they don't care what the court says. They don't care what the facts are in the case.
How did it get set for sale?
All right, it was set for sale originally when Your Honor set the judgment. You gave them a 7-month sale date.
Right.
And then when Your Honor grant, it's improper to move forward with the sale while rehearing happens anyway.
No, I know that. That's why I don't understand how did the sale take place. That's why I'm looking at the docket here to figure out what happened.
Because apparently their plan was to, have the sale, pop the locks, scare my clients into leaving, get them all worried about.
Well, let's not get carried away.
I don't think that that's an intentional plan, but I'm saying that is the position.
I understand. Let me hear from the other side.
Your Honor, this was noticed as a status conference today. There is a pending motion for rehearing.
Yeah, I mean, how can a sale go through when there's a pending motion for rehearing?
My understanding, Your Honor, is
My understanding is the case law says you can't do it.
that is my understanding.
All right, buying at the sale. Was it the plaintiff?
The lender.
Okay,
Yes.
so we're in the same position we were in before.
Except for that my clients had to come home and find their doors locked.
That is a separate matter that I'm not taking care of in this case. You've already indicated what you're going to do or thinking about doing. My question is, how do we solve the problem where we are now?
You can enter an order vacating the sale.
That's true. I don't know if it's going to do any good. It's all the same anyway, but because the lender ended up buying the house. But so talk to me about what about getting the two parties together, which is what I had requested months ago.
There was a mediation, Your Honor, and my understanding is that there was a denial of the loan modification request, as there was nothing. This is set for a status conference that there's no motion, there's no, and there is a pending motion.
I know, that's why I want to know what's going
So
on.
my understanding is that there was an application from application that was denied.
Okay.
And that is the status of.
All right, and what was the date of the denial?
I do not have the date of denial from the. I didn't know was going to be on the motion for a hearing today, or was going to be on the denial of loan mod, because there's simply nothing filed.
No, I was holding off on moving on I was holding off on ruling on the motion for all this or
My
not.
understanding that there was a mediation that it did occur, and
Right.
there was no resolution.
I know. You know why? Because the lender or whoever is the servicer now didn't get things done prior to the mediation. I mean, that was my secret hope, that Judge Zabel would be able to,
I can't say that the lender did not get things done.
all right.
Like I said, this is
But
not.
what happened without disclosing mediation privilege? What happened at the
What
mediation?
happened was this. We found out later, we discussed this now in open court because it was admitted. They came to mediation with a denial letter that had been entered before the mediation and kept secret from us.
Oh, that's right. It's all coming back to me.
And-
Yes,
and-
you're
What
You're right.
I want to make sure we're clear on is, the reason why my clients don't qualify is because instead of reducing the total amount that was owed to create, like they have every right to do, certainly in a case when they're facing the possibility of having a rehearing granted, and now we have to go forward. And I'll say, Your Honor, there's a few judges now. I mean, these counterclaims are now, it's now RICO for forgery, perjury, and destruction.
But we're not in that situation.
Well-
We're past that situation.
Well, that's the question.
We've got a judgment here.
Right, but the motion to vacate judgment.
I understand.
I just want to make
And
sure.
you're trying to
There has to be some.
wrap that all into something. I got
I
you.
just want to make sure the court's aware of what I'm trying to go with is this. Rather than work with us, which is what Your Honor gave them every incentive to do, they went in and they took the number that is higher than the judgment amount, significantly higher, and used that number to say, so your income doesn't qualify. If they had reduced, in my personal foreclosure with these same issues, without seeing a piece of paper, they reduced my mortgage to a third of what I owed and paid $18,000 in cash to resolve my personal foreclosure years ago. So
Well-
they could have, my point, Your Honor, is they could have done anything to help these people. It's all in their position. And instead, what I see is They never had any intention of doing anything to help my client, no matter how much you were hoping that giving them a look and a nod and say, come on here, you know that this is a case that I could grant rehearing on. And if I open that door, you're going to, you don't want to be in that situation. And I'll just suggest, Your Honor.
Mr. Jacobs, you lost at trial.
No, I don't think that.
Let me just say this. It was, and you all knew this, it was my full intent to deny rehearing. I mean, I basically said that to you all. However, I wanted to give both sides the opportunity to put their heads together and see if this could happen. All you're telling me is that hasn't happened yet. Okay? Because the number is wrong. Now, don't get me wrong. I'm sure that the other side is not ecstatic. Don't get me wrong, but they're probably not ecstatic with your advocacy. Okay? So my question is, how do we, Mr. Jacobs' clients, together on a reasonable, to see whether or not this really can be done?
Yes.
Hold on, let me hear from.
Sure. Let's just set for a status conference of these.
Right.
This was a guess what the issue was going to be today.
Right.
Okay, so my review of the case shows that there was a loan modification request and there was a denial. As to Mr. Jacobs' other representations to the court, I cannot disagree with them, and I cannot agree with them because this was an ambush. And if he had all these issues, which are concerning, he should have put them forward in a motion and not done it this way. And brought to the court's attention in a written motion so we could respond in a written motion, and then it would be before the court. I think I think the case law says is that the purpose of the status conference is not to ambush the other side with.
No. I want to get past that. I'm a great believer in looking forward as opposed to looking behind us and see what happened to get us here. So, my question is, can you talk your client in loan modification offer based upon a newly submitted package, which I'm going to have them submit to you all?
I can always talk to my client, and I always can advise my client. It's going to be up to my client to decide what they'd like to do. But if the court would like us to consider a new modification package,
Yes.
We always could. I can't tell you what my client is going to say.
No, I'm not directing either side what result to come out with. I just want to see if there's any possibility. I want to maximize it. That's all.
What I could say is definitely, Honor, is we could definitely review it again. I'm new to the case, and that we could set it for a status conference. Maybe I'm not trying to tell you what to do, and 60 days from now, and then talk about the results after that.
Okay.
Can I make a suggestion? This would be with respect to the 10th package that my client has submitted since this started. And the last package she submitted, she was perfect. And remember, she's in the mortgage industry. She this whole thing started. She knows how to package. She's done it perfectly. The problem I see is they have zero incentive, and they're making that very clear. We have a judgment. He's not going to vacate that judgment. They have zero incentive to do it, and that is what this is. That is what you don't do. What they did to these people, pop their locks, send them evictions while this on a sale that you did while the rehearing was pending in the court. All of this, you've done everything you can to give them the other suggestion on this. Grant the motion for rehearing. It doesn't do anything. It just puts us back to a position where you're going to be one of many judges that I'll be doing the same work I'm doing on, and some of them are way further advanced than what's going on here. So you're not going to be, it's not like all of a sudden tomorrow you're going to have to say, oh, there's fraud in the case or anything. I think that you could, just on Sorensen.
I'm not ruling on the motion for rehearing today.
Well,
all right. So I understand. So what I want is, you all know, because you've done a bunch of packages, and I'm looking at your clients, Mr. Jacobs. I want you all to resubmit. Whatever the most current package is that you can, with all the most current information. How long is it going to take you to submit that?
2 weeks.
Okay, so today's the 20th. All right. I want the package submitted by April 5. Okay, that's Friday. that's a Friday. And then I want, how long does it normally take for your client to look at the package and determine?
Well, Your Honor, it's the complete package. All those things are governed by
It's supposed to be 30 days under the rules.
statute.
Right. So,
I would want to, since there is a judgment there, it would be every incentive for my client to expedite looking at it and doing it thoroughly and quickly as possible.
right, I agree with that, but I want it to be a fair look.
Yeah.
And you can tell your client I said that.
Sure. And so I think in this case, it'd probably just be better that we guide it by what the parameters of the statute is and how long we have it.
But you're right, 60 days is a fair period to give to, to put it on for.
Just trying to know the procedures under the regulations in the next.
And then you've got the appeal period. Is that what you're going to get into?
Once we have a complete package, they have 30, under the rules, they have 30 days to give us a response.
Right.
Then we have 15 days to appeal. That's just the timeline, so that you are
I know.
aware of that.
I know, that's where I thought you were going to go, but she knows what she's doing because she was in the industry.
She's been through this many
And
times.
so,
Mayor, can we also have an order that vacates the sale? Because it's not gone through.
Your Honor, that wasn't properly noticed. If there should be a motion, and I think the case law is very clear that.
no, but I got to tell you, you heard what my statement was at the beginning of this before hearing anything from either side on that. I was surprised that the sale went through. So, it's not supposed to. You have agreed with me that the case law is that you can't have a sale that goes through when there's a motion for rehearing pending, which is why I didn't rule on the motion for rehearing.
That is my understanding, Your Honor.
So I am going to vacate the sale at this point. Okay. So, let me have an order to that effect, please. And then set it down. Hold on. Let's see. Today is March 20th.
Actually, I have the-
Take a look at May 29. That's a little bit more than 60 days. That's a Wednesday. That's for the next
status.
report from you all. So May 29 at 9:30. Are you both available or not?
I'll make myself available, or someone from my office will make themselves available.
May 29th
Yes.
at 9:30. That looks fine for me. You guys available? Does that work?
Okay with me.
May 29th is a Wednesday. 9:30.
It's a Wednesday?
Yes.
I'm on a missions trip with the church.
For how long?
Cuba. I get back that same day, but I think 12 o'clock in the afternoon,
When do you leave?
the 24th.
All right. I'm going to move it up 1 week, May 22nd.
Thank you.
Ability on
Your
that.
Honor, we'll make.
All right, Mr. Jacobs.
We'll be all right. We'll be there.
Okay, May 22nd at 9:30. All
At
right.
this point,
Has the package that she's got to fill out, has that changed at all? Are you aware of anything in the last few months?
I'm not aware of the last package she filled out was,
Okay.
but I do have a package that I will send to Mr. Jacobs as soon as I return to my office. And then
Okay.
he can pass on to his clients.
It's
All right.
probably the same, I imagine.
It probably
I don't
is.
believe it has, but I did not see the last packages.
Okay, the last package was like 6 months ago, something like
I
that.
don't think it has
Maybe
changed, Your
less.
Honor, in that. but I
That's
do
my
have
gut
the
too.
Most recent one, so.
Okay,
And just so we're clear, you're still going to hold the hearing in Paynes?
yes, that's correct.
Thank
Yep. Okay, all right, thank you all. We'll see you on the
Thank you.
22nd.
Thank you.
But let me have the order setting aside or vacating the sale, please.
This is number 5. This is the last case.
All right,
Morning, Your
the
Honor.
best for last. you know?
Yes. Sharia
All right,
is on
number
behalf of JP Morgan Chase. This is our motion to reset foreclosure sale, Judge.
Granted, I've looked at it. I want to restate. What are you asking for in terms of a future date?
The
please?
next available time, Your Honor.
Okay, it's going to be May 6th.
Thank you.
Excuse me.
Have a good morning.
Thanks. You too.
This is the case.